to get logged in here. All right, here we go. Well, welcome. I'm Casey Vincent. I'm the Director of Events for PACE, and our moderator for our session today is Mark Roth. He is partner at Cobalt Law. So this session is the new FTC, what compliance issues to watch out for. So he's going to just kind of go over a few things, but this is definitely open discussion. So feel free to raise your hand and holler out some questions when you want. So Mark, take it away.
Thank you very much, Casey. Very much appreciate the opportunity to be with everyone here today. I see some familiar names and some new names. I see some folks who are very active in the compliance space and others who may be new. We see my good friend Isaac there from Grupo, who nailed Florida 1120 all over that, helping clients navigate that mess, that mishigas down in the Sunshine State, which is just a real problem and is actually causing some real problems and lawsuits, real lawsuits. And so Florida 1120 is not good right now. But we're not here to talk today about Florida and 1120, unless we do want to talk about that, we can get into it. But the short answer, at least from my perspective, Isaac may tell you differently. You might be hearing from other call centers. My advice is just don't call into the state. Just don't go there unless you pick up an old school phone and go with the circular dial and then wait for it to go back around, then do it again and then do it again. That's the only time you should be calling into Florida to make sure you're not automated, whatever that means. But I know other folks have opinions on that as well. But as an outside lawyer, and I'll tell you about myself in this moment, it's a really difficult statute to comply with. Anyway, my name is Mark Roth. I'm an attorney with a law firm called Cobalt LLP. We are based in Berkeley, California. I am in New York. I am a consumer protection lawyer. I've been practicing for a lot of years, I think coming up on 30 in the consumer protection space. I began my legal career at the Federal Trade Commission right out of law school. And I worked at the FTC for 5 years, where I investigated and prosecuted a number of bad actors back in the day. But I'm now on the other side of the table and have been for many years advising clients on staying out of the FTC's crosshairs. And so that is my practice now. I've actually been working in the telemarketing space back when I started working at the Federal Trade Commission, at that time investigating telemarketing fraud. And then after I left the FTC, worked at a law firm and joined the ATA, back when it was the ATA. It was actually American Telemarketing Association before it became Teleservices, which then later became PACE. So I have deep roots in the space and enjoy working with the folks in the organization very, very much. So that is my background. My intention today was to talk about some recent developments at the FTC that some of you folks may have been hearing about, and if not, this may be the first time you're hearing about it. And it's not directly related to telemarketing per se. I know that during this conference, as well as other PACE events, we talk about telemarketing, in my view, sometime a bit ad nauseum. There are other issues that go along with, in the name of the association, which is a professional association of customer engagement. And it's about engagement. It's not just about telemarketing. So however you engage with your customers, at least to me, is relevant, topical, and should be discussed among members about what best practices are, ways to avoid staying out of the FTC's crosshairs, and also just treating your customers fairly and correctly. So that is kind of where I'm coming from today. And the topics that I want to talk about is the aggressive posture that the FTC has been taking in the new administration. Since President Biden named the new chairperson for the FTC, her name is Lina Khan. She's primarily an academic and she primarily focuses on antitrust. However, she's also taken a very strong stance in consumer protection matters and is now also recruiting other staff to come in who do have a very strong consumer protection background. the FTC's become, at least shooting the first shot across the bow, much more aggressive in its claiming authority to obtain civil penalties in cases. The reason I phrase it like that is because they've had a couple of losses recently, particularly at the Supreme Court, where the FTC for many years in settlements has been imposing and obtaining civil penalties for certain types of bad acts under Section 13 of the FTC Act. With the section of the FTC, that section of the FTC Act, however, was determined by the Supreme Court recently in a case called AMG that the FTC did not have authority to obtain, pursue, or obtain civil penalties in certain cases, in administrative cases. Instead, it only had what's called injunctive relief. So if there was a company that was engaged in bad acts and the FTC investigated that company under Section 13 of the FTC Act, they can only obtain injunctive relief. That means behavior, meaning they can either prohibit a company from doing something, or they can require a company from doing something that would hopefully rectify what the bad acts are or were. So that was a real slapdown to the FTC coming out of the Supreme Court, where they lost this ability to obtain civil penalties. There are other ways to obtain civil penalties for the government that they do still have that right, but if they do want to obtain that right, they have to go through a formal rulemaking process, which could be very lengthy, involves comments, and is not an easy layup for the FTC. And as you may know, that the FTC, they are able to seek civil penalties for violations of rules. So for example, the telemarketing sales rule, which is relevant to most folks on the phone today. A violation of the telemarketing sales rule does subject a defendant company to a civil penalty of over $43,000 per violation. $43,000 per violation. That can mean an errant call. It can mean calling someone on the do not call list, etc. So they do have the authority to get civil penalties for violations of a rule or a particular act of Congress, such as if for those folks who were involved in the recurring charge space under ROSCA, the Restore Online Shoppers Confidence Act, if you violate that law, you are subject to $43,000 per violation. Last, if you are under current settlement with the FTC and you violate that settlement, the FTC can seek civil penalties of, again, $43,000 per violation of the settlement. But those are the only ways that the FTC can get civil penalties. Well, not until recently. As a matter of fact, just the beginning of October, the FTC announced and issued press releases announcing that it has the right to seek civil penalties in certain instances where they put companies on actual notice that behaviors that they have previously determined to be deceptive and misleading, whether in court cases or in other matters, as long as they put a company on notice that they consider behaviors to be violative of the FTC Act, they then, on a going forward basis, can obtain civil penalties for those violations once the companies are on notice. This, folks, is a game changer, a sea change, in that prior to this, and by the way, the notice was sent out is called a notice of penalty offenses. I actually wrote an FAQ recently that I sent out to clients and colleagues yesterday. If you'd like a copy of that, if you can contact me afterwards, my email is mark@cobaltlaw.com, or if you want to send it in the chat, I can hopefully cut and paste fast enough while we're speaking, but otherwise reach out to me, mark@cobaltlaw.com, and I will send you FAQs that I created about this new development. In the middle of October, October 13th, I guess just a week ago, 2 weeks ago, the FTC announced that it sent letters to in excess of 700 companies regarding the use of deceptive or misleading testimonials and endorsements and fake reviews. The letter was sent to advertising agencies, to advertisers, to marketers, large companies and small, with no rhyme nor reason, unfortunately, as to why these companies received the letter. Now, keep in mind, as long as someone is on actual notice, that means receive the letter, they are on actual notice of these violations. And if they continue, or not if they continue, if they engage in these behaviors on a going forward basis, the FTC can investigate and seek civil penalties. It begs a question why the letters were sent to certain companies and not others. They were sent there, and as a matter of fact, the FTC even said in its letters to the companies, we are not alleging that you did anything wrong, which is pretty astounding that they decided that there were 700 companies who they found did not break the law and did nothing wrong, however, were worthy of receiving this letter, thus putting them on notice and being subject to civil penalties. As for the thousands of other companies that were not on the list, and that's what we call it, by the way, the list. It's almost McCarthy era language. For companies that did not receive this letter, they are arguably not on notice of the notice of offenses that will be subject to civil penalties. So again, it begs a question as to why this possibly could be very unfair to those companies who are on the list, again, who have not been alleged to do anything wrong, but nevertheless, they received this notice, and now they are at a competitive disadvantage because they, for violations, any misstep, could be subject to civil penalties for any violations of the FTC Act, particularly with respect to the use of endorsements or testimonials. The FTC also, by the way, has guides. It's called the guides for using endorsements and testimonials in advertising that do provide guidance for companies in this space who do use endorsements and testimonials. But also the FTC talks about fake reviews. And if companies are engaged in fake reviews, that is pretty much garden variety deception. But now the FTC, whereas previously under Section 5, they were not able to obtain civil penalties for just misleading or deceptive advertising. Now they are going to be able to do that. Just yesterday, the FTC announced that it sent letters out to over 1,100 companies in the money-making claim space. That means work from home, gig economy, other types of just working from home, making money. I've not gone through that list entirely. I did go through the list of the 700 for the misleading endorsements and testimonials. I've not gone through the list of the 1,100 companies engaged in the earnings claims notice of penalty offenses, but there are tons of companies listed in there. Hopefully none of you who are on the phone are on that list, but nevertheless, those companies are now on notice. Last, the FTC, prior to sending out the notice about misleading testimonials and endorsements, sent letters out to companies, to the for-profit universities, for-profit schools, also under the same theory that we are going to put you on notice that the FTC believes that claims must be substantiated for earnings, and especially if you go to these universities that claim you have to get a certain degree and that you can make a certain amount of money, then the investment is worth it. They've investigated a number of those companies. By the way, so is the CFPB. It's not just the FTC, but the FTC will go after these companies as well to obtain civil penalties. So I want to that's what I wanted to put out there for folks to kind of think about. And if there are any questions about that, or I'd like to open up the table for conversation around it. All of these people just going off mute, Casey, banging questions out at me. I don't know if I can handle all this pressure. Either I did a really, really good job of summarizing the FTC development so that they have no questions at all, or they're asleep, or they're playing Candy Crush. I don't know. Or it could be all three. I don't know.
There's another alternative, and that's that, the fear is setting in and everybody's kind of taking it in the Halloween spirit, wondering when we're going to have, the FTC knock on our door with a trick instead of a treat. So it's really scary with all of that. So I guess trying to think of, and I feel like in the industry, we're always, it's hard for us to be proactive. We're almost being reactive because every time we think we've solved for the latest problem, we find something new. So obviously you want to have truth in advertising. I know that there's been a lot of talk on the Hill about false advertisements or false reviews. And I know that's a big thing that they're currently working with, but are there any proactive steps we could take from an education perspective, even at Pace, where we could say to members, hey, stop doing this before it's too late?
Absolutely. It's a great point, Isaac. For the most part, it's advising members to be aware of what the there's two prongs. One is just knowing and respecting basic FTC jurisprudence, deception, misleading practices. If you're going to say something, be able to support it. If you're going to engage with influencers or anyone else on social media, and you're incentivizing them to do something, have a hashtag, some type of disclosure, either ambassador or something like that. So there's one just general compliance, being aware of, and general compliance with FTC rules and guides. The second is to understand the priorities. And the new administration now, one, they're going to be going after companies that they feel have been intentionally flouting the law, ignoring the law. There's also a strong push on privacy. They are hiring a lot of privacy and technology lawyers, and the FTC really wants to the extent it's not already itself, to establish itself as the privacy agency for protecting consumers' privacy. And we think we see that trickling not just to every company, but also in big tech. The big tech companies are already kind of under the microscope and, if you will, under the fire of Commissioner Khan, whether it's Google, Facebook, Amazon, the large tech companies and that's not just, by the way, from a consumer protection standpoint with respect to marketing, but also antitrust. The FTC has a lot of concerns, as does the EU, with how large these tech companies are and the type of power. So, and what they also do is they buy up small, when there's an upstart competitor, they just buy that company out. So in any event, I go off on a tangent there, but to answer your question, I think it's education, remaining aware of what the issues are, of what general compliance should be. Again, not just to avoid FTC or regulatory scrutiny, but treating customers fairly and honestly, understanding where the priorities lie, because there's some areas that are kind of, if you will, hotter than others right now.
Okay, Mark, I'll bite. My question is this: get out your crystal ball and tell us where you think this is going. Okay,
so I'll tell you. So I used to get questions like this. By the way, I love doing live events. Doing this virtual thing is difficult because I don't have props and stuff. But I used to, if you remember Carson, I used to have a Karnak thing. You just put the envelope. I'd have a question, and then you tear it open, and then you take the question out.
That's why I have the question. I remember your Karnak gigs.
And I'd have someone with like the hat, like the Karnak hat too and everything. So this is how these things play out. The FTC put something out there, the shot across the bow. Hey, world, this is what we're going to do. What they don't always do is come out with guns blazing. And when I say always, because this is a different administration right now, but historically what they do is they put something out there, almost like floating a balloon. They want to see how people react, and then they're going to take action. But they're not going to come out historically with guns blazing. They'll typically come out, investigate a company, and then issue a closing letter. Now, a closing letter just simply says, we looked into this, and by the way, that's public. We reached out to this company for information about certain practices. They advised us that they did X, Y, and Z. That satisfied us. And so while we're not saying what they're doing is right or wrong, we're going to close this investigation. It's called an administrative close. What that does then, it says, hey, world, we're on the beat. We're looking out for this stuff. We really do mean it. The first example here, we didn't come down hard on. We didn't bring the hammer, but we just want to let you know that we are looking, and these are the types of issues we're looking at. That, Dennis, has been kind of the history. Like, for example, if you ever remember, it was literally 11 years ago, the first social media disclosure for material connection case was Ann Taylor. And Ann Taylor, what they did was they encouraged and incentivized bloggers to come to a loft opening, and they gave them sweepstakes entries and other swag, et cetera. And they had a policy that required them to make a disclosure that they were getting all this stuff for free if they were posting it in social media. and a lot of them didn't, yada, yada. Fast forward, the FTC brought an investigation, but they didn't go to a complaint and sue them. What they did was they issued a closing letter, and they made that very public. So what I'd like to think is the same event is going to happen here. They've put out this big statement, and they're going to go after some companies. They'll put out closing letters. But this, again, this is a new world here. This is a new administration. And Chairwoman Khan is very aggressive. It's very possible they may go after very egregious players and activities in this area and might bring the hammer. So we don't know yet how aggressive they're going to be. Everything that they're saying, that they're alleging here, or that they're putting out there, it's nothing new. All of this, all of the points raised by the FTC in their notice, it's all garden variety FTC Act 101. So it's nothing new here. It's what companies should have been doing all along, and that's what companies should be doing right now. What it is, it's a wake-up call for companies to look at, okay, how are we engaging with endorsers? What endorsements are we using from customers? How are we using customer reviews? Are we adopting customer reviews as our own? And so there's a lot to think about with this development. Again, it's a wake-up call so as to avoid FTC scrutiny. I'd also like to think that they're only going to go after bad actors. Sometimes they just go after cases that are layups, and they may not be challenged by large companies that may have the wallet to fight back, or where something's in the gray. Hopefully, most legitimate companies are, if anything, in the gray and not doing something totally wrong. But it remains to be seen how aggressively the FTC is going to go after whether small companies doing really bad things or large companies doing bad things, or maybe going in the area of the gray. We just don't know right now.
Mark, I have a question. Our little group here has litigated against the FTC quite a lot over the years, and frankly, a lot of our cases are the sort of the more egregious examples. We're defending defendants who are accused of flat-out fraud. And as you know, in the past, under Section 13B, they've often started these cases with preliminary injunctions, really TROs that turn into preliminary injunctions and freeze orders and so forth. How do you think that this AMG case will affect that kind of remedy? Because we frankly have not had anything new this last few months to sort of see what they might do.
Right.
We see that they're sort of taking a different tack with the cases we do have. They're issuing CIDs and going through the administrative route with investigatory hearings. But I kind of wonder, and frankly, we've not really dug too deeply into it. I wonder, do they still have that remedy at their disposal? Because of course, for the clients and in some ways for us as well, that kind of attack is very difficult, very challenging to deal with.
Yeah, no, it's a great point. Andrew, thank you. And I think I recall we may have worked together. You're in Florida, is that right?
I am.
Yes. So I think we have worked on a couple of things years ago. So it's good to see you.
I believe so.
It's good to see you.
Good to see you too.
So for everyone on the phone, or the web, the Zoom, I don't know what to call it. I still call it the phone. This is a telephone call. Anyway, goes back to my ATA roots. So what Andrew's referring to is what I mentioned at the top of the call about the FTC losing this AMG case where the agency is not able to get civil penalties for certain offenses. And then what also Andrew's mentioned is under 13B, if there's really egregious acts by a company, the FTC will get what's called an ex parte approval from a court or even through the commission itself to shut down a company. Like, for example, a boiler room, or just a really egregious player, to shut them down immediately, so that, because if they got notice of an FTC investigation, they might try to flight, they may try to leave either the country or wherever, or they might try to take all their assets. So what an action under 13B is, it effectively gives the FTC authority to get an immediate injunction prohibiting a company from engaging in the bad acts, and an asset freeze. Not in all instances, but in some instances, they can go into a bank with a court order and halt and freeze a potential defendant's assets. That is kind of the real hurt there, which is the money. Then they have to get an approval from a trustee to have money taken out to even defend the case and to pay their employees and yada, yada. So without
Or
that,
their lawyer.
or the lawyer, right, exactly. Most importantly, the lawyer. But what that real hammer, though, is the ability to get the money to then that would either go to the Treasury or go back to consumers. And so without that ability to have that financial aspect of the injunction or of the freeze, it really kind of hurts the agency. And that's what Andrew's talking about, is that they've not been maybe as aggressive in going after those cases now. And they're simply issuing CIDs, that's a civil investigative demand, or a subpoena for information. There are two approaches, by the way, the FTC, and I'm going to actually answer Dennis's question from a moment ago as well. You know, what do we see? How does the crystal ball, how do these things play out? The FTC, for really egregious behavior, such as slamming or cramming credit cards or engaging in really violative telemarketing practices, that's when they'll go after a company very hard, and they'll either try to get an injunction against them or a TRO, et cetera. But most cases, probably 90%, if not more, the FTC has two courses. One, they send what's called an access letter. It's a letter they send to the company that says, "Dear company, we are writing in connection with certain activities that you may be engaged in that we think that might violate Section 5 of the FTC Act or any particular rule, et cetera. In accordance thereof, we'd like to give you an opportunity to respond and provide information to us." That's called an access letter. That's a friendly letter. It means the staff is concerned, but they're not overly concerned. Then what you do is you review the letter, and it usually asks for documents or information. You then, through yourself or through counsel, reach out to the FTC, and you either try to narrow the scope of the letter, or you try to, I think someone's got a phone on, I'm getting some feedback. You try to narrow the scope or the delivery of all the information that you're going to submit. That's the nicer approach. If the FTC is authorized to issue a subpoena, then you are compelled. And by the way, the access letter, you're not compelled by law to respond. It's not smart to ignore the letter and to not respond. It's a very good idea to respond and to engage with commission staff. But if you receive a subpoena or a CID, that has the force of law. And if you don't respond in the time and manner, then you could be held in contempt or obstruction of an investigation. And that's when things get really thorny. What I see potentially, in particularly when I was just talking about the endorsements and testimonials, there's not necessarily harsh consumer harm here. No money's being taken out of consumers' bank accounts. No phone calls are being made to consumers in violation of do not call. What they are these, if you will, a passive approach. It's advertising and marketing. It's not making a disclosure about an endorser or about an influencer. It's posting a fake review possibly, which probably is the most egregious in everything that we're talking about here. So in all likelihood, the FTC will issue an access letter to target companies asking about their practices in this area. And so I don't see the FTC coming out guns blazing in this area, particularly with respect to endorsements and testimonials. On the other hand, the other areas, the make money earnings claims, that can be a bit more egregious, and that can also have real consumer harm because these companies made these earnings claims that may not be able to be substantiated. So in that area, it might be an access letter, it might be a subpoena. But the endorsements and testimonials, I very likely see an access letter going out asking about how the company conducts its marketing campaigns. The for-profit universities, similar, if not even more egregious than the how to earn the earnings claims, because that can be that can also hurt consumers. What you want to do then is, now this goes back to Isaac's question, like what can we do now in addition to education, is let's look inside and ask internally, what are we doing? Are we using endorsers and testimonials? Are we using consumer endorsements? Are we getting them off the web and then putting them on our site? Are we incentivizing consumers to write endorsements about our products or to give reviews about our products and services? What do those policies look like? Who owns that internally? Understand where this is being done, to what extent it's being done. Are we incentivizing people to do this? And then to see if they comply with the points that are in the FTC's notice. And so we can be proactive there. That way, if we ever do get a letter from the FTC, we can respond with a smile on our face and confidence saying, dear FTC, thank you very much, for taking a look, but we've got this covered and here you go. Here's our policy and here's what we do. And, you can move along. There's nothing to see here. That's kind of the best reaction you want to give to the FTC if they approach you in this area.
I see Sheldon asked a question. Doesn't really have a simple answer, but since it's your session, you could jump on that one. He's asking in what exact time in Eastern Standard Time a call center can call.
In Eastern Standard Time? Well, that depends on the state. It's not just Eastern Standard Time.
Yeah, no, it's that's why I said it's not a simple answer. So I figured
it's not right. Yeah, it's not a simple answer. And also, Sheldon, it's beyond the scope of this panel. But nevertheless, yeah, it depends on the state. And if you're in Florida, you shouldn't be calling in there without express written consent. I know Isaac differs with me on that one, but okay.
Well, and that's really the thing, since Florida's now come up twice, I think, it's one of those things where, I remember I had a talk with Nick Whistler, like the day after the big cell phone thing happened in 2015 or something like that. And there was all the language about ATDSs thrown in and stuff like that. And Nick's response was, well, I'm using my Office PBX. I wouldn't even use that to call you on your cell phone because, that could be, considered an ATDS. And as time went by, a lot of the click to dial by and large was accepted as the bare minimum that everybody said, yeah, if all that system requires is click to dial and all this other stuff. So I think what it's going to come down to is, one of the lessons I saw with the cell phone stuff in the TCPA was people were a little overcautious. It hurt business. That's not to say play loose and wild, but I think ultimately it's going to take a few cases to really pan out in court for us to know, and kind of build a real opinion. So now it's either, I've seen companies that do 10% of their revenue in the state of Florida. And so for them to stop calling is just huge.
Right. Yep.
But on the same hand too, I could see an attorney saying, well, look, I make money representing you in court. So if you want to make me rich, call, just have at it. So there's definitely the conservative side. There's the slightly less conservative side. And then there's the reckless, just.
Yeah.
I'm gonna do what I want to do.
All the things we talk about are really kind of risk analyses. What threshold for pain or risk do you have? Florida, like the TCPA, scares the bejesus out of me because you've got a private right of action.
Absolutely.
And there's no what's called there's no regulatory prosecutorial. Well, these are big effing words. Right? Sorry, I just cursed. Casey,
No.
That's okay.
You didn't quite curse.
Is effing okay? That's okay. All right. So, okay, ready? It's regulatory prosecutorial discretion. Okay, use that in Scrabble. Anyway, what that means is regulators, before they bring a case, or even when they're bringing a case, they have discretion in whether or not they're going to want to prosecute or not. They have limited resources. Do we want to use our resources towards this? What are we going to get if we bring this action? So they have, and they're accountable. They're accountable because they have a budget and they have a limited number of people. On the other hand, class actions can be brought by anyone at any time with no accountability. Now, if a class action firm brings an action, they're typically doing it on what's called contingency, meaning if they don't win or they don't get a settlement, they're not getting paid. They're doing this with the hope of getting a settlement or getting a judgment or if they get money. But if they lose, they're out a lot of money, and that's really bad. But nevertheless, if they do initiate one of these cases or an individual sues either for themselves or on behalf of a class, then the company has to defend. You have to go to court. You have to hire a lawyer to appear for you. You have to draft responses, etc. That is why when some of my clients get a TCPA demand for $1,500, sometimes I tell them, write the check and get a release. Put a gag on the recipient. Because you're going to pay me $1,500, by the end of this phone call. So write the check. Let's get done with this thing. And that's why, like the new Florida law, has an explicit private right of action in the law, in that section of the law. And you have the word automated, which is not defined anywhere. That is why that just scares me. And I advise clients, unless you have prior express written consent, which is similar to, but not exactly like the TCPA, calling into Florida for marketing purposes is really risky. And we're already seeing that. As a matter of fact, a couple of my clients have already been sued, not even on marketing, but on, it wasn't even a marketing call. It was kind of a billing call. But this complaint was fashioned as a violation of the law. What does that mean? My client has to defend it. They have to file an answer to have it dismissed. And so you gotta, it's distraction, it's cost, et cetera. And that's where, going back to what I said before, Isaac, about, well, how much tolerance do we have for making calls in there? What's the likelihood someone's going to sue us? Do we have deep pockets? Do we not? What's the nature of the call? Is it truly marketing? Is it informational that may be cloaked informational and maybe me marketing? There's a lot of risks, a lot of things to think about in there. And on that front, the telemarketing stuff scares me. The other stuff, the FTC things with the endorsements and testimonials. And as a former FTC guy, when I used to wear a hat, not my Karnak hat, but one of the hats, and I used to have a badge, like Dragnet and all that, and everything was in black and white, right? Then there, it's like when I was an FTC lawyer, I would sit at my desk and something would come on my desk and we look at it and go, is this something I really want to pursue? Is it what are we going to get for it in terms of bang for the buck? Or do they look like they're trying to do the right thing? All right, pile this, pile left. Or is something I really want to investigate, put it in this pile. You want to have the FTC look at it and go, that's not the thing. For Star Wars fans, it's not the droid you're looking for. And so that's really where you want to be. You want to be in the droid pile, okay? And no one trademarked that. I'm going to do that soon as I get off the call. It's called the droid pile. And that's the pile you want to be in so you don't get investigated. So there we go. If you took one thing away from this, you now have a new pile of something. What else we got, folks?
Mark, Ken Kreitzer's CBSI in New York. I just was curious, which bill is that you were referring to that about in Florida that impacts anyone calling in?
That's SB 1120, Senate Bill 1120.
Is that passed or is it pending?
Oh, it's passed.
It passed, it went into effect it got the signature from the governor the day before it went into effect. July 1st is when it went into effect this year.
Correct.
It's a good read.
I'm already defending 4 or 5 of them.
Is that part of?
I'm already defending 4 or 5 of those lawsuits.
Is that part of a privacy initiative or is it separate on consumer?
Telemarketing.
Just telemarketing.
And it's really convoluted in that most of us who reviewed the bill, what it does is this amendment, it amends the Telemarketing Florida Act, the Florida Telemarketing Act. And the way the Florida Act is written, it's 4 different sections, different parts. And part of the bill amended part of this law, part of the law and not another part. And then there's an exemption, there's an EBR exemption. So a number of us thought, oh, well, I have an EBR, I can continue to call. Oh no, each part is separate, even though it's all under the same act. And so it's really convoluted, Ken. There's been a lot of ink spilled over it. I think Pace put out a lot of content on it. Isaac's put out some really good content on it, really good thinking on it. So read up on it and just, at least for me, be scared, be really scared. I think it's gonna, Andrew said, he just mentioned a moment ago, he's already handling a number of these cases. I'd like to handle a number of those cases so I can put my kids through college. But I'm not a litigator. I'll handle those over to Andrew. But there's been a lot of activity in that space. And
Mark, when did you say?
July 1st.
July 1st. Okay.
Just past July 1st to went into effect.
Hey, thank you very much.
Sure.
Yeah, we're kind of wondering how it's going to play out because the standard is lower than it is with TCPA for what defines an auto dialer and so forth.
I mean, that's the thing about the TCPA. We have the definition of an ATDS, both statutorily as well as how the Supreme Court has ruled on it, which is great, right? It narrows it.
Finally, a decent one, yeah.
Right, exactly. I mean, hello, random sequential, 1991. That's what happened back then. People ain't doing it now, at least legitimate people. But that pesky word capacity, Andrew, still, that just scares me too. But at least we have a definition to work with. In this law, Ken, in this Florida law, this SB 1120, it says any automated system for placing phone, for the selection or placing of phone calls. So even if you use a preview dialer, arguably, I'm not saying yes or no, I'm not making a judgment here, but if you have a preview dialer where the dialer automatically selects, not the dialer, but the system pulls the number without rhyme or reason, that arguably could be an automated means. And that
I think it is.
The law.
Yeah, I absolutely, as a non-lawyer, I absolutely think that, and that, see, that was the thing when people were comparing the TCPA. I said, well, the TCPA is about the technology you're using at the heart of it. You know, it's all about that ATDS, whereas this is about, Florida's about methodology. And things like click to dial and preview dialers and all these things people came up with. And some people were pushing the boundaries of TCPA with like the manual predictive dialers and things like that. But if that, yeah, that, in my opinion, as I read it, the preview dial where you get the call and you click the dial and you think in the spirit of things, it's slowing it down. It's the person initiating the call. So I'm talking to them. That's not good enough as the way I read it.
Yeah, that's right. It's just, it's a real, and we don't know what it means. There's no definition. There's been no decisions. The law, by the way, has been there. It has been there. Automated's been there in the law. That did not change. The other aspects of it changed, the definition of prior written consent and the private right of action. So it's possible that this law, it's not possible, the law has been on the books, but it's been rarely, if ever, enforced by the Florida AG. Now you have private right of action.
Right. I think they removed some clause in there, though. There was a huge exemption in there where if you could prove that you subscribe to the state do not call list and you follow certain best practices, there was this really gracious exemption clause in there that was just, you know, had a line right through it in the 1120 final version.
There may have even been an EBR, Isaac. I don't know. I don't recall exactly.
I think there was, but it was. Yeah, those exemptions, I mean, if you go in and you read 1120, and I remember when that was on the table, because it was that one, and there were like 5 bills that were similar. And I remember looking through them and I saw 1120, and that was the least scary because it was exemption, exemption, exemption. And I went through this thing and I said, who does this even apply to? I mean, this covers, I mean, it wasn't just EBR, it was, you know, if you're in this industry and that industry, hospitality, I'm like, well, okay, Disney's good, you know, all these people are totally exempt. And then when all the other ones died, and this was the only bill that was left, I said, okay, well, if that one passes, I'm not going to lose any sleep.
Right.
And then I had another read and another read and another read. And anytime I go back and read it, I've got to have it up here. And then I've got to have the state statute here. And I'm just like, wait, this line goes there. And it's, and
it removed the exemptions. That's exactly right. It pulled that right out. So, So we're coming up on our time, Casey, and I know that there's something right after this, so I don't want to hold us up. Just to kind of wrap up, we have a really aggressive FTC out there in this new administration. They're putting out a number of announcements and notices, putting the world on notice that they are going to be seeking civil penalties in areas where they historically have not, and arguably did not have authority to do so. But under Section 5B1B, I think, they do have this right to put out a notice to companies that will then be used if there are violations going forward to obtain civil penalties. So something to think about if you internally, if you're a company, if you're not just a service provider and you do use consumer reviews, or you use endorsers or influencers, time to kind of look inside your house and see if you're in order and if you're complying with the FTC guides. If you want a copy of my FAQs that I put out just yesterday, please send me an email. My email is in the chat. Thank you very much for that, Casey. So we've got a very aggressive FTC. We also, although not intentionally, we did cover 1120 down in Florida. It's a bear. There are cases going on already. But if you're not familiar with it, definitely read up on 1120 and the Florida Telemarketing Act. Haven't seen other states get as aggressive as that. There are some other aggressive states. Indiana has historically been aggressive, but Florida is really an outlier right now in that space. And then last, TCPA. You can't have a PACE session without talking TCPA. We had some, a really good decision earlier in the year. As a matter of fact, on April Fool's Day with Facebook, really good decision. We think it slowed down plaintiffs' cases, but they're still coming in, and it's still, at the end of the day, an extortion statute. They get the right to sue you. If you want to get out of it, you're going to have to pay some way. Either write a check now, or you're going to have to pay the lawyers later. I'm not going to tell you which way, Andrew and I feel, but, it's, pays the rent. But in any event, that's kind of the wrap up for today. Really appreciate so many people showing up. This has been really terrific. I appreciate those who participated in the session. Really helpful, helped conversation flow, and got some really good ideas out there. And if anyone does want to continue conversations, you have my contact information, reach out to me. Happy to help you. I'm pretty passionate about this stuff. Love it. And so I think that's about it. And with that, I will close. Casey, hand it back to you, and hope everyone has a great conference.
Thanks, Mark.
Great session, Mark.
Thank you, everyone.
That's great. All right. Thanks, everyone. We have a
Thank you,
social starting just about now. If you'd like to join that, it'll be a lot of fun. But again, thanks again to Mark, and we'll see everyone tomorrow. Bye.